Hello. Hi. So I'm Naomi and I'm from the Law Reporters. And for today's webinar on labor law of UAE, we have Ms. Rintu from NYK law firm, and she will be the the host for the webinar today. So welcome, Ms. Rintu.
Hi, Naomi. Thank you for the opportunity.
Of course, of course. We'd love to get into what you have for us today. So why don't I give you the platform? The stage is yours.
Thank you so much. Welcome, everyone. Good evening. This is Rintu Raju from NYK Law Firm. I handle employment and immigration litigations here at NYK. As it's clearly said, we will be discussing certain key provisions of the UAE labor law, certain frequently asked questions, which if the time prevails, we will be addressing most of it. So let's start the webinar without much ado. I hope I am audible and you can see my screen. If there's an issue, please drop a message in the chat box. Okay, as I said, today we will be discussing the UAE labor law. First of all, in UAE, there are various kind of labor law considering where you are employed with or where the company is located. The major labor law that is followed is, of course, Federal Decree Law number 33 of 2021. This is applicable to all private sector establishments. However, this law will not apply to government or federal employee. It will not apply to defense, armed force, or police department, and this law will not apply to domestic workers. All those sectors have their own individual different labor law. Today, since the majority of UAE is handled by private sectors and majority of the residents here fall under the private sector, we will be discussing this law and we'll be addressing certain key points here. So first of all, the major first important document in an employment relationship is, of course, the employment contract. There are how do you identify what is your employment? First document will be, of course, the employment document. If your company is located in mainland, you should have a Mohore employment contract. If your company is located in a free zone, if you're employed with a free zone company, you will have a free zone employment contract. Since these two documents are given by the government, it will only have some basic, the most important provisions. If the companies want to ensure that many other restrictive covenants, for example, non-competition, non-solicitation, confidentiality, if such provisions has to be detailed, obviously they should have an internal employment contract, which talks more about the policies of the company, the objectives of the company, the rules and regulations inside the company. So second, can an employee, so this is a major question that we always get on a daily basis, that the employer is charging me for my recruitment or the employer is charging me for my visa, for my work permit. Obviously, the UAE labor law don't allow such kind of practices. It's totally prohibited. You cannot charge the employee for any amount of money, directly, indirectly. There are instances where it says, I mean, we will charge you for training, or we will charge you for so and so. It's not accepted as per the law. The only circumstance where an employee can actually take money from the employee is when the employee is not uh, adhering to the notice period. So that is known as a compensation for notice period. Otherwise, no money can be taken from an employee. Let's talk about termination. Before before going to termination, there are two types of there are two types of issues here. Let's talk about termination in the probation period and termination in a regular employment. So when we speak about probation period, as you are aware, probation period is from 1 month to 6 months. Of course, and in the probation period, let's say if an employer wants to terminate you, he has, I mean, he can give you a notice period of 14 days. Okay. Vice versa, let's say if the employee wants to terminate the probation, he will have to, first of all, adhere to the uh, notice period mentioned in this contract. Other than that, if he's terminating the contract, let's say he wants to go back to his home country, doesn't want to work in UAE anymore, he wants to go back to his home country during the probation period, he should serve the notice period of 14 days. Okay. If he is getting a new employment in the same, I mean, in the country, and he wants to switch the employment during the probation period, of course, he will have to serve his notice period, and the employer has the right to claim compensation from the new employer for all the expenses that he incurred, be it visa, be it work permit, even training, provided it's supported by proper receipts. So that's the major, issues with the termination during probation period. Now, let's say if somebody leaves the organization during the probation period, and he comes back within 3 months and he joins a new employment, this is still considered as he has left for a new employment. The new employer can still claim for compensation. Can a termination during probation challenged? Well, it depends. Now, if the termination is due to uh, performance, of course, then it will be, as I said, the employer has to give 14 days of a notice period. If the termination is due to some documentation issue, he has to give that reason of why there is a termination in the probation period. Otherwise, this is the usual norm. If whoever is initiating the termination has to give a clear reason of why the termination has been issued in the probation period. Next on the list is leave. So as you all know, the major three leaves in UAE is annual leave, we have maternity leave, and we have sick leave. So speaking about annual leave, well, annual leave, once you complete 1 year, you are entitled to 30 days of annual leave. During the probation period, you are not entitled to any leave. And if you're taking a leave during a probation period, it will be considered as an unpaid leave. So, however, simultaneously, each month that you're in the probation, the two leaves are getting collected in your bucket. So it is getting accrued against your name. And as you complete your probation period, you are entitled to take those leaves. Those leaves become legal. You're entitled to go ahead with it. Uh, if at all, before completing, let's say after the probation period, you resign and you leave the organization, whatever the leave you have accrued during that period, you can claim leave encashment from the company. Next is maternity leave. Each employee is entitled to 60 days of maternity leave, out of which first 45 days a paid leave, following which the 15 days will be half pay. If there is any complication during the childbirth, wherein, let's say, the mother or the child, due to some medical reason, has to stay back and continue their leave, they can get another 45 days of extension, provided they provide sick leave certificate. And that brings us to the next point, which is sick leave. Now, in total, an employee is entitled to 90 days of sick leave in a year. out of which 15 days will be a full pay, 30 days will be half pay, and the remaining will be no pay at all. If an employee has exhausted this 90 days option, companies do have the right to terminate the employee for taking too many leaves. Again, sick leave is not you're not entitled to sick leave during the probation period. What other type of leave do we have in UAE for private sectors? Well, one is bereavement leave. If there is a death in the family, if it's a death of a spouse, then of course it's 5 days. If it is any other family members, it's 3 days. When we say family members, it's excluding your in-laws. So grandparents, parents, siblings, all of them, we can claim a 3 days uh, bereavement leave. In-laws are not considered in this bracket. For students who have completed 2 years of employment, can always seek a 10 days of paid leave if they are pursuing any kind of education in the time of the employment. And for paternity leave, it's 5 days within the 6 month of childbirth. Apart from that, national employees, Emiratis employees have a right to take sabbatical leave to perform their military duties. Now, one of the biggest question I always get is about commission, bonus, and incentive. Let me explain it to you. When in your employment contract, your contract has to be very clear about your remuneration. So when I say very clear, it will talk about your basic salary. It will talk about your breakups in the salary. What are the benefits you are getting in your remuneration? So ideally, by law, when I say basic salary, it's considered that anything else you're like, whichever you're getting as a bonus or a commission is already included. Okay. If the company has a policy of paying bonus on top of what they're paying as a remuneration, they first of all, the company has to have a very clear policies in place about how the bonus or the commission is calculated. And if possible, if you are an employee, I will always recommend that you get an explicit document from your employer if there is any bonus or commission due to receive. Because most employment document will only talk about calculation, like you're entitled to 5%, you're entitled to 10% of the commission or maybe bonus. But when tomorrow this becomes a litigation, it becomes very difficult to prove before the court what is the exact figure, because you might not have access to most of the confidential detail of how this whole calculation is made. So whenever you're leaving the organization, it is always advisable that you get a clear documentation from the employer that what is the calculation and how much is the amount you're supposed to get. If possible, you can get it on your entitlement calculation sheet itself. That would be great. Next, we'll talk about termination of the contract for regular employee. So what are the grounds for termination? Number one, of course, if both employer mutually agrees to terminate the employment, then that's a termination. It has to be in writing, very clear, because there are cases where employer just verbally says that you are terminated. That's not enough. You should have it in writing that the relationship is terminated. If the contract has expired, if your whole employment is based on a contract, then, and if it's very clear that it will end on this particular date, then that means on that date it's more or less considered as a terminated employment. If when of course, if either of the party has issue with renewal, they don't want to renew the contract, and they beforehand gives information that, I mean, they tell the other party that, oh, we don't want to renew it, please consider this as a termination, then it's surely a termination. If there is a death, when I say death and disability, of course, if the employee is dead, then of course it's more or less a termination. But what about employer? So if your employment relationship is with the person in personal capacity, then on the death of the employer, it's considered as a termination. If the employee is sentenced for some criminal offense wherein the punishment is more than 3 months, it's more or less a termination of the employment. And of course, if the company goes through bankruptcy or a closure, then it's considered as a termination. Now, how to process a termination or resignation? Obviously, you will have to give in writing, as I just said, that either the employment is terminated or you want to resign from the organization. Both the party has to abide by the notice period clause, and notice period clause is either from 30 days to 90 days, not more than that. We have to ensure that the whole handover procedure is over. Like if the employee has any kind of assets of the company, he should ensure that it's all handed over and gets proper acknowledgement of the same. If for the company also, they should ensure that all the requisite handover they want to take, like for example, if the employee is dealing with customer details, then all the handovers are completed. And of course, on the last working day, it's always advisable that on the last working day, you send across an email to the employer saying that, listen, I've done all my handover, all the I've complied with my policies. This is my last working day. This is basically to keep a record that you worked through your notice period. Because sometimes, or most of the times, we have noticed that the company goes and files a dispute saying that the employee never followed the notice period. So it's always advisable that you put on record that you're serving your notice and this is your last working day. Now, notice period. As I just said, notice period is, of course, between 30 to 90 days. So, how does notice period work? In the beginning of the webinar, I told you that notice period is only time where you can actually take a compensation from the employee. So, there are certain circumstances where the company don't have to give notice or where the employee don't have to serve notice. Like for example, let's talk about termination. Obviously, when we say termination, it's the termination initiated by the company. If the company is terminating the employment for forgery or breach of trust, which is more or less a criminal offense, uh, there is no requirement of notice period. It's an immediate termination. You don't even have to. The company don't even have to pay notice period compensation. If the employee has caused a huge material loss of the company, let's say he has deleted the confidential data, then that's a very, very big breach. Of course, that's immediate termination. If he has caused any kind of violation of the regulation, if there is a performance issue, if he has disclosed details, sensitive details of the company to a third party, and if he is absent for a longer period of time, which is like absconded from employment for a longer period of time with no information, all of this can be used as a termination without notice. The company can terminate you without and don't have to pay you a notice period salary. Coming back to the employees, when can employee put across a notice period, like put their resignation and don't have to serve their notice period is when there is a breach of the employment contract. Like for example, you're supposed to be joining on this date or you're supposed to be paid this amount, and there's a direct breach of the contract. The employee don't have to serve notice. There is any kind of violence inside the organization, the employee don't have to serve their notice. If there is some severe health hazard issues in the workplace, of course, that you don't have to come back to serve your notice. And you're fundamentally, I mean, you are assigned to do some work wherein you're supposed to be like you're hired for something else. So that's basically a breach of the contract. You don't have to serve your notice. You just have to give your resignation and you can leave. So there is no compensation paying back to the company in such scenarios. Let's talk about payment in lieu of notice. How is this calculated? So let's say your contract says your notice period is 3 months, okay, and you have not served that notice period. The company can ask you to pay 3 months' salary back to the company, to the employer. Vice versa, if the company asks you to leave and that you're not required to serve notice, in that case, the company in their entitlement, they will have to include 3 months of salary as payment in lieu of the notice. Let's get to our next point, which is end of service gratuity. Now, so this calculation is only for the private sector employees. So for every employee who has completed 1 to 5 years, you have to complete 1 year first of all. If you have not completed 1 year, you are not entitled to gratuity. The moment you complete 1 year, you become eligible. So 1 to 5 year, they will calculate 21 days of basic salary. And for someone who have completed 1 year, it becomes 30 days of the basic salary of the year. So that's how the calculation is done. And of course, when you leave the organization after the last working day, within 14 days, the company should ensure that all the payments are released and the cancellation is processed. If within 14 days, the company is not processing your cancellation or not completing the settlement, you have the right to go ahead and file dispute, which we'll discuss in the further part of this webinar. Can the company deduct from your entitlement? Yes. So let's say you have taken any loan from the company that can be deducted from your full entitlement amount. Let's say you have some payments pending, outstanding, all of that can be adjusted in your full entitlement amount. If you have a ruling from the court, I mean, the employer has received a ruling from the court where, let's say, there's an execution case against you, and you are not making the payment, and the employer got a notice of it, the employer can withhold your entitlement and pay to the court. If you have caused any kind of damages in the company, damages can be of two kind. Let's say they filed a case against you and then they have a judgment in their favor where it says that they are entitled to receive certain damages from you, they can recover it from your entitlement. There are cases where credit card companies reach out to your employer to confirm your employment and you default the credit card payments. They can actually, reach out to the company and get the payment from the company if you have entitlements pending to be paid. So these are the legal deductions that's allowed in the entitlement. If you don't have such circumstances, of course, then the company can't touch your entitlement. They have to release it within 14 days. Now coming to labor dispute. Earlier, whatever disputes you had, like for example, if you were a mainline company, you reach out to Mohore and Mohore will try to amicably settle the dispute. And if they're unable to settle the dispute, they will refer the matter to the labor court. If you are a free zone company, you reach out to free zone. Free zones will do the same exercise. They will try to amicably settle it. If they are unable to settle it, they will move the matter to the court. However, recently, there is an amendment in the whole process. If your claim amount is below 50, Mohre has the right to pronounce judgment. So you approach Mohre, like if it's a mainline company, you approach Mohre. Mohre will file the case. They will call the opposite party for their statements. Now this time it's not more like earlier it was discussion. Now it's statements. They take statements of both the party. It goes on the record. And accordingly, Mohore gives a decision. And within 15 days, if the parties are not appealing it, you can actually go for execution and claim that money from the opposite party. But if the claim amount is above 50, the earlier procedure stays. You go to Mohore, Mohore will give a referral, it goes to the court. What happens to free zone company? Do they also have the right to give a judgment? Not really. If you are a free zone employee, you reach out to free zone. They will try to amicably settle this dispute. I'm talking about if the claim is below 50. So you reach out to free zone. They will try to amicably settle the dispute. If they're unable to, they will move it to Mohore. Mohore will act like a court and will give a judgment there. And then same process, you can get it executed after 15 days. If your claim is above 50,000, do you still have to go to Mohore? Answer is yes. So after the free zone authority, you go to Mohore. Mohore will give you a referral. So this time you have two referrals, and then that goes to the main court, and then the procedure will start. Now, well, some of the major questions I get every now and then is what is the minimum wage? Well, for private sector, there is no minimum wage policy. Private sector employees, there are work permits or employment contract which even says 1 dirham. So there is no minimum figure, like explicit figure, or this is the minimum, you can't go below it. There's no such policy. But it's always advisable that as per the category of the employee that you hire, you maintain that standard of minimum wage. Like for example, if you are hiring someone who comes in the professional category, there should be a bracket. You have to ensure that the employee is in that, I mean, the payment is in that bracket. Some other question I get is, what is the compensation for arbitrary termination? There is no provision of arbitrary termination. It's purely an employment relationship on the contract. When I say employment relationship on the contract, I mean each party has the right to terminate that employment. The only time where an employee can claim compensation for termination is suppose he has filed a case. Let's say there is some issue in the organization, you filed a case before More or maybe before the court, and because of the case, the company terminated you. In that situation, you can claim an compensation for arbitrary termination, and that's the only scenario where you can claim compensation. Because in such case, the court also has the right to decide whether they should pay you How is it calculated? It's as per your salary. So it's like 1 to 3 months. So the court can decide whether they should give you a compensation of like 1 month or 2 months or 3 months, not beyond that. Okay. And another question I get is, I'm working on a job offer letter, visit visa. Can I file a Mohre complaint? Answer is no. You can't. It's illegal, in fact. You're an illegal employee, illegal resident. Anyone who is on a visit visa cannot work. As simple as that. If you're found working, both you and the employer might end up having penalties. So when you go to file a case, you don't have a Mohore contract to begin with to file a case. So maybe you will not be able to proceed further. But if you want, you can go ahead and reach out to Mohore and try filing a violations against them. But of course, you might also end up having penalty. It's actually not advisable. You should not be doing it. From the day one itself, there should be a valid work permit and valid visa from the employer. So I have finished my talk. Now let's open the forum for questions. Naomi?
Thank you so much, Ms. Rintu, for the insightful session. Yes, we do have a lot of questions reeling in regarding the employees and their rights.
Sure.
So first, we will go on to Ms. Gayatri. She had a question regarding she wants to resign her job immediately because, I mean, an employee wants to resign the job immediately because their wife passed away. In this situation, do they get a notice period from the employee or no?
You will have to serve your notice period. So when you say you are resigning, are you planning to leave the country as well immediately after the resignation? First of all, are you in your probation period or are you a regular employee?
If that was the situation, let's say she would have to leave the country and she's also on probation, what would the
If she is
scenario be
on
like?
probation, then in that case, obviously you're resigning to leave the country. You have to still serve the 14 days notice period. You will have to reach out to your employer, I would suggest. Reach out to your employer, show them the records of the incident. See, it's obviously it's something very serious. The employers might waive off the requirement of notice period, and if both the parties are mutually agreeing to it, then it's fine. You can leave and go back to your own country and uh, take care of the other issues. But see, the idea is it should be mutually agreed. If the employer is very adamant on you serving the notice period, then you will have to either pay him the 14 days salary or you will have to serve the notice period, unfortunately. You can also put a request for bereavement leave. Okay, so you have to sit with your employer and try to navigate this situation because it's death of a spouse. This is death of the spouse, right? So you have to show them the documents, request for a bereavement leave, and maybe tell them that I'll come back and serve my notice period once I'm back from the leave, or else ask them for a waiver of the notice period.
All right, all right. And there was a follow-up question from Ms. Sanjana Gupta. She was asking if the bereavement leave and other leaves are counted under the total leaves given by the company.
No, these are separate. Total leave is okay. Now, 30 days is annual leave. That is separate. Sick leave, you have to support it with your sick medical certificate from a authority, medical entity. So all of those are separate. Bereavement leave, it's upon circumstances. If there's a death in the family, it's a separate circumstance altogether. Okay, so it's not like there's a total leave. The total leave that you can claim is annual leave. Rest, everything is as per the circumstances. If you're hospitalized, you get a sick leave. If there's a death in the family, you take a bereavement leave. Support your request with the documents.
Right, right. Thank you, thank you. And there was another question by Miss Priyanka, where she asked, "What is the duration of the sabbatical leave? A UAE national employee can take, and whether 2 to 3 weeks is allowed or not."
It depends on how long is their military entitlement. If their military entitlement is, let's say, a year, you have to provide them a sabbatical leave of that particular period. So they will also have to submit their documents to show how long they want the leave to be.
Okay, all right. And we had another question from Ms. Sanjana Gupta, where she was asking where the ILOE pays the insurance when the employer has terminated an employee.
Yes. Yes, absolutely. So ILOE is I didn't cover that in my talk, but ILOE is basically involuntary loss of employment. You have to register yourself and ensure that the premiums are paid and everything is up to date. If not, you might end up incurring a penalty of 400 dirhams. Um, if you are terminated from the employment, of course, the employer has to ensure their cancellation is processed. In the cancellation document, it should be clearly mentioned it's termination. Uh, Also, it should not say termination due to disciplinary reason. There is a high chance that your ILOE request will get rejected. If it's termination due to redundancy, if it is termination due to financial restructuring, they will calculate as per your basic salary and they will give you payment. And I think the maximum they pay is for 3 months. So whoever is getting terminated, ensure that your documentation is very clear about it. Okay, and yes, you do get paid. It's already been, I mean, people are getting paid for now.
Okay, okay. And does everyone, are they entitled to a 3 month salary after the termination?
No, salary, ILO is not paying you salary. ILO is basically just supporting you. Okay, they
Oh,
are supporting you with your insurance. That is not salary. Okay, so the amount that they will pay, it will be based on the salary in your employment contract. Okay, that's separate. When you are getting terminated, you are getting paid for your notice period. That's it. That is coming from the employer.
right, right. Okay. And there was another very interesting question from Ms. Sanjana as well. And it goes like, what if the employer terminates you and gives you garden leaves? Are you not required to work?
So garden leave is basically it's a notice period wherein you are not required to report to work. So you are not, I mean, you cannot go and seek a new employment. You can of course go for interviews. You are just that you should be available when the company needs you. You're not required to report to work during the this garden leave period. However, you should be available. It's more like a honeymoon period, as we say. You will be at your home. They will be paying you your salary. If there is an emergency at work, if you're required to come up or show, I mean, if you are required at any point of time, you should be reachable. It's okay for you to go for interviews. Uh, you can't leave the country, but everything else is fine. Otherwise, in normal notice period, even when it's notice period, you report to work like a regular employee or like a regular employment, in fact. Okay, you report to work, you are there by the timings, you do everything that you did before you served your designation. So in garden leave, that's not required. You stay at home. At your own comfort. Just you should be reachable wherever it's required.
Okay, okay. Thank you for clearing that up.
Sure.
We had one more question from Miss Reshma Saldana. She was asking if whether when an employee takes more leave than their entitled allowance from January to December, as in for the entire year, and they
Mm.
resign before reaching the full, entitlement, will the company recover the paid amount for the excess leave taken from the final settlement, that is?
It totally depends on what kind of record the company is keeping. Okay, first of all, see, I need to know the numbers. I mean, when you say entire leave, how many leaves has he taken? It all
More
depends
than
on the.
let's say more than the allotted ones. Let's say more than the sick and more than the annual and more than the additional leaves that they are given.
See, ideally, let's say you joined an organization in Jan, okay, and we are in August, for example. Well, from Jan to August, you are entitled to 16 days. Approximately, it's 2 days per month. Okay. Let's say you have already taken 20 days of leave. So it's company can adjust that 16 day in the leaves that you're accrued in the bucket during that period, and remaining 4 days, it should be ideally an unpaid leave. Let's say they overpaid you. Okay, they have to come back and show how is it overpaid and how they are adjusting in your entitlement. So this is something which the company has to be very mindful of. They have to maintain record of it. Okay, so it's always advisable. I'm not sure if the who is asking the question is from the company or from the employee side, but if a companies are listening to me, they should always maintain a clear record of wherever their overpayments are happening. If they are unable to prove that, then they can't touch your entitlement. If they're able to prove that, then it's always a mutual discussion between you and the company.
Okay, okay. So, okay, thank you for clearing that up. Now we have a
Mm.
question regarding the maternity leaves. And
Mm.
according to your session, you had explained that it's for 2 months,
Correct.
right?
It's
So
okay.
is it only possible after the baby is born, or can they avail it before, like maybe
Yeah.
on the seventh month?
Sure, it depends entirely on the mother. She can decide when she wants to avail it. She can even start at the third month or the second month itself. But the point here is, it's 45 plus 15, so that's the total that she can ask. So she can plan it accordingly, and it's fine. It's nothing like the baby has to be born or this particular date onwards only you are entitled. Nothing like that.
Okay, okay. All right. And now we have a question from Ranjana Ramnath. I think this is from an employer's perspective. Can the employer increase the notice period? Yeah. Is the employee's written consent, required for this? And
Any change in the employment contract has to be mutually consented by both the parties.
all
So
right.
let's say you join the organization on a notice period of a month. Let's say 6 months after that, the company thinks, oh, we should maybe increase, any change for that matter, not just notice period. They plan to change any kind of information on your employment contract. It has to be mutually consented by both the parties.
Okay. And what if, in the case of where the employee is refusing to sign, can the employer terminate the employee, or does
No.
it go to court?
See, termination, just for this ground, they don't usually terminate. They will, of course, come up with some other ground. But it will be like the first contract, which was signed by both the parties, all the provisions of that contract will remain. So let's say they are terminating you saying some other reasons. Of course, they can't cite this as a reason. If they say some other reason we are terminating you, then whatever the notice period is mentioned in the original contract, you will have to follow that.
Okay. All right. Thank you for that. Now, there's a question from Mr. Prash, and this is regarding the exit clause. If when the employer imposes visa fees as training cost, is there another way out of it, or can it be calculated on the pro rata basis?
Employee can't take visa fees or training fees or recruitment fees or insurance fees or medical fees or any such fees from an employee. That's it, full stop. The
Okay.
only claim that an employer can make is when you're not serving your notice period. Other than that, no employer can take any money from the employee directly or indirectly. If you are exiting the company, and at this stage, if the employer is saying that, oh, we will charge you so and so for whatever training, you have all the right to reach out to the labor authority, file a complaint against them, and appease them about this. Okay, and take this further as a take this forward as a dispute.
Okay. So there are quite a few questions about ILOE insurance. One is whether it is when if they are applicable for when they are working under the husband visa, and can you just explain a bit more on the concept of
ILOA
ILOE?
is absolute. It's connected to your work permit. Okay, when your visa status is basically an immigration. It's an immigration subject matter. Okay, so if even if you're working under a spouse or a father, you still have to obtain an NOC from the sponsor, give it to your employer, and then they will process your work permit. That's the process. So
Oh,
your ILOA will be connected to your work permit. It has got nothing to do with your visa status. That's number
oh,
one. The moment you join an employment, you should be ensuring that all your ILOE premiums are completed. there should be 12 premiums paid. So obviously the first payment itself is multiplied by 12. You have to complete an year in the organization, and it's only for termination.
Mhm.
Also, if you are terminated due to disciplinary reason, you will not be able to claim ILOE. If you are terminated for financial restructuring or any other reasons except disciplinary, you can still claim your ILOE insurance. For that, you will always have to reach out to Tashil centers with your cancellation document. So when you might have seen when you cancel, I mean, it comes from Mohore, or if you are a free zone company, you will have the cancellation document from the authority, not from the employee, not from the employer, from the authority. You need that document signed and stamped by them. Reach out to any Tashil center. Tashil center will, there's a process in place. They'll make you fill some forms. As per your basic salary, they will do a calculation and they will help you out with the payments.
Okay, okay, all right. And could you elaborate on the difference between a mediclaim insurance and term insurance?
That's an insurance concept.
Okay.
So that's
Uh,
totally different. It's medical insurance is basically different, and term insurance different. That's a choice between, that's a personal issue.
all right, all right. So we have an entire scenario described by Miss Isha, and
Mm.
this is a scenario where the employee wants to resign after joining, and the notice period is 2 or 3 months. But can the employee pay for this notice period so they can join the other company immediately? Because the employer cannot find replace and handover done as quickly as
Mhm.
possible, but they're willing to pay for this notice period and
Okay.
leave.
Like the employee is willing to pay to the employer the money, the compensation.
Yes, yes.
Okay, it's fine. If you're willing to pay the notice period compensation and don't want to serve the notice period, it's your free will. You can definitely settle it then and there, and then you can, um, go join the new employer.
Okay,
This
so
is probation period, or
notice,
is it
notice.
no? But are you resigning in your probation period, or is it regular period?
No, it's a regular period.
It's fine. Then it's fine. Mostly, what happens is like, let's say you have finished 1 year in the employment. Obviously, there is certain entitlement that you are supposed to get as on date. So mostly, what the employer do is they deduct that 1 month salary which you not did not serve the notice period, or whatever the notice period is. They will deduct that from the total amount, and then they will pay you whatever is remaining. So if that's okay with you and you are okay with that kind of deduction, it's fine. You can just get it settled and move on to the new organization.
All right. And Ms. Ranjana had another question regarding the arbitrary termination. Is it still available under the new law? And if yes, what will fall under the
No, there
arbitrary
is uh,
termination?
there is nothing called arbitrary termination or compensation for arbitrary termination. The
Mhm.
only scenario where you can actually claim a compensation for termination is if the termination, if you were terminated after you filed a case. If you filed a case, the employer was informed about it, and the very next day they decides to terminate you, then in such scenario, of course, you can claim compensation for arbitrary termination.
Mhm.
Otherwise, for any other terminations, you can't. I mean, normal termination scenario, you can't ask for arbitrary compensation.
Okay. And if the employment is under a limited contract, even if there is no explicit agreement, is it signed to that effect?
Yeah, it is. I mean, this is the law. This is provision. This is the legal provisions. So even if, let's say, first of all, that it's not necessary that the other party has to give you a reason for termination. But if you feel because you filed, I mean, it's not feel. If you have a clear evidence that because you filed a case and after like next month they've terminated you, then it's very clear cut. It's a very clear case that this termination has come because you filed a case. So you can go for compensation. Otherwise, no, it's a normal. If it's normal, then you really can't ask for compensation.
Okay, okay. All right. Thank you so much, Ms. Rintu. This has been a very insightful session that we've had this evening.
Sure.
There are a lot of questions, but I suggest that anybody that is still having any doubts on this employment sector, and if they have any more further clarifications that they require, please do reach out to the law reporters or Ms. Rintu directly, and we'd be able to further help you after this. So thank you so much again, Ms. Rintu, for being a part of this.
Thank
And
you.
we look forward to having many more sessions with you.
Sure. Sure. It's always a pleasure, Nayani. Sure.
Thank you.
Thank you. Bye bye.